and posted on the results website along with the PowerPoint slides. And I'll recap the background. Basically, we, the department, have updated Chapter 2 of the non-regulatory guidance for the migrant education in order to reflect changes made to the authorizing statute, that is, Part C of the Elementary and Secondary Education Act of 1995, the SEA, that were made by the Every Student Succeeds Act of 2015, ESSA. And we released our Chapter 2 on our MEP state listserv the same day it was approved by the department, which was March 3rd. And we delivered a nearly identical presentation to today's webinar for our MEP state directors during our annual directors meeting here in Washington, D.C. on March 7th. So at this point, we've inserted the revised Chapter 2 into our existing guidance, which contains a total of 12 chapters. The guidance document is currently posted on the results website. That's results.ed.gov, and you can find it under the legislation page. We do know that chapters within the guidance are also in need of updating because they were last updated in 2003. So we will be revising those at some point in the future. And just to provide a very brief background on the rationale for starting with Chapter 2 and give an idea of the stakeholder input that was considered in the development of this guidance. This started at the annual directors meeting in 2016, which was right after the law passed. At that time, we had more questions and answers about the eligibility changes, but we did consider all those questions, and they were informative in shaping our guidance Chapter 2. We also met a group of state directors through the coordination work group in June 2016, and we were able to solicit some feedback from directors and their states and their region through the question. We received feedback from Interstate Migrant Education Council in June of 2016. And then, of course, we also considered all of the questions and concerns that we heard from individual emails and our conversations with them. So all of that went into the development of this guidance, and you'll see today posted on the results website.
We're getting more comfortable with.
I'm just going to pause for a second and ask everyone to please mute their phone. Otherwise, all of the background chatter will be picked up on the recording. So please mute your phones so we can have a clear recording.
Be able to go back to the source.
And now to go on to the objectives for today's presentation.
Yeah, so we had to go and dig back in. You know, Louise was looking back in through the law. And
I'm going to see if I can mute everyone's phone.
She was like, how do I do that?
The conference is now in silent mode.
I believe I was able to mute everyone, but well, hopefully that'll clean up the recording somewhat. So objectives for today's presentation are to understand the basic requirements for MEP eligibility under the ESSA, to become familiar with the department's non-regulatory guidance on child eligibility, that is Chapter 2, and to accurately apply these requirements in accordance with the department's guidance using some eligibility scenarios. Now we know we do have a lot of state directors on the line, but we also have some new participants, and we know this is your first introduction to a lot of these changes. So just to reassure you, it's intended to be an overview, and we don't expect anyone to memorize the content right away. That takes time, and like any change, but especially in a topic as unique as eligibility, reading of the guidance, consideration of various eligibility scenarios, and conversations with your colleagues for all of this information to sink in. And then I do want to mention that there's natural overlap in this presentation and the national COE, which is currently subject to revision. We'll be out for a second public comment period, the revisions to the national COE, and that should be posted hopefully in the next few days. So everyone will have another chance to comment on the national COE. And we will try to point out some areas where there's overlap with the COE or the COE fields, particularly for the eligibility scenarios. And then one more just piece of logistics. I do want to mention that we know a lot of questions might come up during our presentation. With so many participants, I think we're maxed out at 95 right now. So we're going to ask that if you do have questions, please submit them in the chat box. And we will pause. If we have extra time at the end of the presentation, we're going to try to get through as many of those chat box questions as possible. Given our limited time this morning, though, we might not be able to get through all of the questions. So in terms of follow-up, we ask that if you're a MEP state director and you did not get your question answered during today's webinar, please follow up with your program officer to get a response to your question. And if you're a local MEP staff or recruiter, for example, we ask that you follow your state's process for these types of questions. So please submit them to your regional director or your director in accordance with your state's process. And some of those questions might get elevated to OME, but we want to follow your standard process. So now you see before you the references. This is our standard slide for all of our presentations. These are the legal references where you can find the more detailed language that pertains to today's presentation. So we have the statute. Those are the specific sections of the ESSA that pertain to eligibility. We have the Code of Federal Regulations, and we also have the National Certificate of Eligibility Instructions, which, as I mentioned, will be out for public comment once again. And then, of course, Chapter 2 of the non-regulatory guidance. Okay, so in terms of transitioning to these new eligibility requirements under ESSA, I want to reiterate what some of you probably have heard before. That is July 1st of this year, July 1st, 2017 is the key date to remember. New statutory provisions under the ESSA for the MEP will take effect for fiscal year 17 grants awarded to state educational agencies on July 1st. And all MEP-specific statutory provisions in Title I, Part C of the ESEA, as amended by ESSA, including the program definitions affecting child eligibility, will also be effective on July 1st. So what that means is that provided the revised ESSA-based COE has by then been approved by the Office of Management and Budget, or OMB, all SEAs must begin using the new revised national COE for all MEP eligibility determinations made on or after July 1st, 2017. We consider an SEA's eligibility determination to be made when the SEA designated reviewer approves the COE. So any COE reviewed by an SEA designated reviewer on or after July 1st must only be approved by such reviewers if the children on the COE meet program eligibility criteria under the ESEA as amended by ESSA. And one question that I do want to address, because it came up early on in this process, is whether children who are found to be eligible under the current law, No Child Left Behind, or NCLB, would remain eligible for the program after ESSA takes effect, even if those children don't meet the ESSA requirements for eligibility. The simple answer to that is yes. A migratory child whom the SEA determined to be eligible for the MEP prior to July 1st, 2017, based on use of the prior version of the national COE, remains MEP eligible for 36 months from his or her most recent qualifying arrival date, QAD, until he or she reaches age 22, until he or she is no longer eligible for free public education through grade 12 in your state, whichever occurs first. And I will turn it over to Pat for some summary of the changes to MEP eligibility.
Okay, thank you, Sarah. Let's go ahead and get started and look at terms of what has changed with ESSA. So as you'll see here, changes to migrant education program definitions. This is very difficult to read. We have only put this up as a reference slide. We will be going through each one of these definitions, but you'll see in terms of the changes, it is affecting migratory agricultural worker, migratory child, migratory fisher, and qualifying move. So if Yeah. The other thing I would just like to reference again is Sarah did mention that the guidance is on results.ed.gov, and so as we go through the slides, you see this, and the language will be bigger, so you'll be able to read it, but again, their definitions are also in Chapter 2 of the guidance. Okay, so what remains the same? So in terms of children who are eligible, children ages birth through 21 who are entitled to a free public education through grade 12 in the state, or not yet at a grade level at which the LEA, the local education agency, provides a free public education, for example, preschool. So what we're doing here is explaining that it generally the children who are eligible for this program is the same as what was under the previous statute, NCLB. So the definition of child remains the same. So recruiters may identify as eligible any child under the age of 22 who is still entitled to a free public education in your state through grade 12, or is below the grade level at which the LEA provides free public education. Generally, as I've just read, this means that the child has not yet received a high school diploma or a high school equivalency diploma. Children who have moved, okay? Again, the same. Children who have moved as a migratory agricultural worker or a migratory fisher, or who have moved with or to join a parent, guardian, or spouse who is a migratory agricultural worker or a migratory fisher. And the same thing, migratory children are eligible for the MEP for 36 months from their most recent qualifying arrival date, which, again, is the QAD. And as you can see, in parentheses, we have the references to the chapters in the guidance. So this program remains focused on children who move as agricultural workers or fishers, or move with a parent or guardian or spouse who is an agricultural worker or fisher. In other words, mobility and temporary or seasonal agricultural work or fishing are still key to eligibility. Children are still eligible for the program for 36 months from their most recent qualifying date or QAD, or until they no longer meet the definition of child. For example, they reach age 22, whichever comes first. ESSA did make statutory changes in ways that SEA and their recruiters are to determine the eligibility of migratory children. We believe those changes should make SEA eligibility determinations much clearer and easier to document. Next, we're going to review some key terms that are used in our discussion of eligibility. For the most part, these terms are consistent with definitions we've already been using from the program regulations. However, there are some modifications which we're going to highlight for you. We use the term qualifying work as an umbrella term that covers temporary or seasonal employment or personal subsistence in agriculture or fishing. Temporary employment, seasonal employment, and personal subsistence remain unchanged. You may continue to use the definitions in the program regulations. The statute uses the phrase employment in agriculture or agricultural employment and employment in fishing or fishing employment. For the most part, those terms are the same as what's defined in regulations as agricultural work and fishing work. The key difference is under agricultural work. The statute adds dairy work and also initial processing of raw agricultural products. We believe in practice this will generally mean the same types of work activities currently used to determine if a person is a migratory agricultural worker or fisher. However, this may expand to some new work activities. One example, which is in the revised guidance, is that initial processing of trees would now qualify because trees are a raw agricultural product. ESSA added a definition of qualifying move that basically combines the definition of a move that is in our program regulations with the parameters for school districts that were in NCLB's definition of migratory child. Okay. So a qualifying move is a move due to economic necessity from one residence to another and from one school district to another with specific exceptions. And you can see on the slide the specific exceptions. The only notable difference here is under the exception for districts over 15,000 square miles. Those moves used to be limited to moves to a temporary residence to engage in fishing, but now is open to any type of. Based on our earlier consultation with states on the number of school districts that have over 15,000 square miles, it doesn't seem that this change will have a significant impact on eligibility. Okay? I just want to pause a minute and just have people look once more at this slide at the qualifying move to pay close attention that the qualifying move is defined as a move that is due to economic necessity from one residence to another and from one school district to another school district with specific exceptions. Now let's look at QAD, the qualifying arrival date. We consider the QAD to be the date or the day that the child and the worker complete the move to be together. That is, if the child's move precedes the worker's move, the QAD is the date that the worker arrived. If the child's move follows the worker's move, the QAD is the date the child arrived. Okay. Now we show you the definitions of qualifying move and qualifying arrival date in a side-by-side format here to make an important distinction. For many of us, myself included, we often use the term qualifying move to refer to a specific move that makes the child eligible for the MEP, which is the move they made with or to join a parent, guardian, or spouse for the purpose of obtaining qualifying work. Now, if you look at the definition now of qualifying move, you do not see any reference to qualifying work. It just talks about the qualifying move as simply a change in residence made due to economic necessity from one school district to another. Both the child and the worker must have made qualifying moves within the previous 36 months. Okay. The QAD is the date that the child moves as a migratory agricultural worker or fisher. If the child is not the worker, the QAD is the date that the child moves with or to join the worker. Okay. Remember that the child is the one that's eligible for the program, so the QAD has to be tied to the child. The qualifying move is the move. Anyone in the family can make that move that's due to economic necessity from one residence to another and from one school district to another school district with specific exceptions. So if the child is not the worker, you as recruiters will need to determine a few things. One, whether the child made a qualifying move within the previous 36 months. Two, whether the child's qualifying move was made with or to join a parent, guardian, or a spouse. Three, whether the child's parent, guardian, or spouse meets the separate definition of either a migratory agricultural worker or a migratory fisher. Okay, so at this point in time, we're going to talk about what makes an individual a migratory agricultural worker or a migratory fisher. And with that, I'm going to turn it over to Sarah to explore those definitions.
Okay, thank you, Pat. So the most significant changes to program eligibility under ESSA are found not in the definition of migratory child, but in the definitions of migratory agricultural worker and migratory fisher. So we're pointing out the key changes on this slide, and of course you can always refer back to the exact statute language. The first big change is the elimination of what we call the intent factor. Because ESSA no longer contains the phrase "in order to obtain," this enables individuals to be considered migratory agricultural workers and migratory fishers without the need for recruiters or states to determine the intent or the purposes of the worker's move. The second change is the ESSA refers to individuals who engaged in new qualifying work soon after a qualifying move, rather than the NCLB wording, obtained work. So we're looking at engaged versus obtained. This is an important distinction to note in cases where, for example, the individual has a written or a verbal confirmation that they will start work on X date, but they haven't actually engaged in the work yet. Finally, ESSA changes somewhat how individuals who moved but did not engage in new qualifying work soon after the move may still be considered a migratory agricultural worker or migratory fisher. So we'll unpack those definitions further. So there are two basic ways that an individual may be considered a migratory agricultural worker or a migratory fisher. The first one is the most straightforward. The individual made a qualifying move and soon after doing so engaged in new qualifying work. The second way that they can be considered a migratory agricultural worker or migratory fisher is if an individual did not engage in new qualifying work soon after his or her move, that person may still be considered a migratory agricultural worker or migratory fisher only if he or she meets both criteria. They actively sought new qualifying work, and they have a recent history of moves for qualifying work. So for those of you that have been with the program for a while, this language probably sounds pretty similar to the wording that is currently used, but it's essentially an and rather than an or for those criteria. On the next slide, we'll compare the NCLB-based wording to what's required under the ESSA. So, as we mentioned before, as amended, the ESEA no longer requires that a worker needed to move in order to obtain qualifying work. That requirement, and therefore the associated regulatory definition of in order to obtain, are no longer applicable. So naturally, some of the terms used within these definitions raise questions. What does soon after mean? How is actively sought defined? How far back can we look for recent history? Because none of those terms are currently defined in the statute or the regulations, that's where the department's guidance comes in. We will share our interpretation of those terms on the next slide. We'll start with soon after. We recommend that soon after the move be within 60 days of the worker's move, which is 30 days more than it had been under NCLB. We selected this time period in recognition of the change in statutory wording that I just mentioned, where NCLB referred to the worker obtaining work. The ESSA refers to engagement in work. We believe that a 60-day window allows for extenuating circumstances which would delay an individual's engagement in new qualifying work immediately after a qualifying move, while still providing a reasonable temporal connection between the move and the worker's engagement in qualifying work. And the COE instructions, as they're currently proposed to reflect ESSA, they would require a note in the comments section of the COE if the individual is determined to be a migratory agricultural worker or a migratory fisher based on such individual's engagement in new qualifying work more than 60 days of the individual's qualifying move. So in other words, more than what we would consider soon after the move. If they engage in new qualifying work within our guidance's definition of 60 days, then no comment would be necessary. So now moving on to actively sought. The phrase actively sought implies the need to take positive actions to seek such work. So for example, the individual or someone on his or her behalf may have applied for qualifying work at a particular agricultural or fishing job site, or they may have applied at a center that coordinates available temporary and seasonal employment. They may have applied for such employment before moving, or may have moved reasonably believing that, based on newspaper ads or word of mouth, that such work would be available after the move. The department believes that the process of actively seeking new qualifying work should happen within 60 days of the move, or however the state defines that phrase, soon after the move. The other question is how to determine whether the individual actively sought new qualifying work. In our guidance, we explain that recruiters may rely on the worker's statement regarding his or her attempts to obtain new qualifying work. The information, which would include the worker's statement, together with any additional information the recruiter chooses to add based on his or her knowledge of the area and the type of work available, should provide sufficient information to allow COE reviewers and third parties to assess the reasonableness of the recruiter's eligibility determination. And that information would be a required comment on the COE as proposed. Finally, for recent history, the department interprets the phrase recent history of moves for qualifying work to mean a recent history of moves that resulted in temporary or seasonal agricultural or fishing employment, in other words, qualifying work. And we believe recent in this context should mean no more than 36 months prior to the date of the recruiter's interview. So as a reminder, because this criteria only applies to those individuals who did not engage in new qualifying work soon after the qualifying move, we believe that such individuals should only be considered migratory agricultural workers or migratory fishers if they, in the recent past, have moved and been employed in such. Another question that was raised by states early on was about workers who might be moving for the first time on their own, but who have a history of moving with a parent who is a migratory agricultural worker or a migratory fisher. We do believe that you should be able to consider an individual who has a recent history of moves with or to join a parent, guardian, or spouse whose moves resulted in qualifying work as having made those moves for temporary or seasonal agricultural or fishing employment. And similar to the actively sought criteria, recruiters may rely on the worker's statement regarding his or her history of moves for qualifying work. The recruiter should ask whether the worker has ever moved before and request information on the dates of those moves so you can establish that it was recent, and whether the worker or his or her parent, guardian, or spouse engaged in qualifying work after those moves. And like actively sought, a comment would be required on the COE as proposed. With that, before we jump into the eligibility scenarios, we're going to pause for just a couple of minutes so we can review the questions that we've already received in the chat box, and we'll try to get through those while still leaving some room for the eligibility scenarios. Okay, so we'll put you on pause for just a couple of minutes. For your patience as we review the questions, and please continue to keep sending your questions in the chat box. As I said, if we have time at the end of the presentation, we'll try to get through some more questions, but we do want to leave room for the eligibility scenarios. So starting just in order that we received them, the first question is about a scenario related to engaged. So if a family moves on August 1st and the worker immediately engages in qualifying work, and by the time the recruiter finds the family a month later, the worker is no longer engaged in any qualifying work, can we qualify them based on that original work engagement? So the basic answer to that would be yes. So you are looking at the definition of a migratory agricultural worker, or it could be a migratory fisher. And in that definition, they still have to meet all of the criteria, so they must have made a qualifying move, so you establish that their move was across political lines due to economic necessity, one residence to another. You establish that the qualifying move that the worker made was within the last 36 months, and it sounds like they did meet the criteria. Soon after their qualifying move, they did engage in new qualifying work. So that would meet the definition of a migratory agricultural worker or a migratory fisher.
Do you want to read the MEP eligibility requirements again?
Yeah, so we had another question about the transition to ESSA's eligibility requirements. We're flipping back to that slide. So I'm not sure what the question was on here, but just to reiterate that the transition will be effective on July 1st, 2017. Maybe this is about the COE, which I think was a related question. So that means that, so this is assuming that the revised ESSA-based COE has by then been approved by OMB. All SCAs must begin using the new revised COE for all MEP eligibility determinations made on or after July 1st, 2017. And this goes to a second question, which is what happens if a COE is signed by the worker and the recruiter on June 30th, but does not reach the SBA verifier until July 5th? Can it be evaluated based on NCLB or under ESSA? So we do say, and this is in the guidance as well, that we consider an SCA's eligibility determination to be made when the SCA designated reviewer approves the COE. That's what makes it official, is that approval. So any COE that's reviewed by an SCA designated reviewer on or after July 1st, that scenario was July 5th, must only be approved by such reviewers if the children listed on the COE meet program eligibility criteria under the ESSA.
And did you want to go to the question over there?
Yes, and then we have, just keeping on that same topic, we have a question. What happens if the national COE is not approved by July 1st? Can the SCA use the most recent template available to collect documentation after July 1st? And also, can the state update their COE using the most recent template available before July? So for now, what we are telling states and what we have been saying consistently is that everything becomes effective on July 1st, 2017. With that said, we know that date is quickly approaching, and we are well aware of all of the prep work that goes into making that transition. We know you need to update your IDNR materials and your trainings, update the COEs themselves, whether they're paper or in electronic form, actually provide the training to your recruiters and your reviewers, ensure that they understand it. We know there's a lot of work that needs to happen before July 1st. So we have been doing our best to communicate that internally in the department. In our communication, we have requested an expedited review by OMB if possible, trying to communicate the field's concerns. For now, July 1st is still the effective date. And if we get closer to that date and the COE has not been approved right now, we're estimating OMB's approval by May 31st. If we get closer to that date and things have been delayed or there are other issues raised, we will revisit that and we will communicate any changes to states. But right now, we're looking at July 1st, 2017.
Okay. There's a question about the recent history of moves, or the two moves. Let me read it then. If the two moves that resulted in engagement in agricultural work, in terms of the recent history, do they have to be across school district lines? If one of the moves is across school district lines and the other one is not, but they both resulted in new agricultural work and they are within the past 36 months, would that still qualify?
Still qualify. Yes, so, and we do explain this in the guidance as well. So when you look at the reference to the worker's recent history of moves, it does not say recent history of qualifying moves, which, as we know, includes that criteria for from one school district to another with those exceptions. So in terms of the recent history, it only needs to meet the regulatory definition of a move, which is a change from one residence to another residence due to economic necessity. So in that example where one of the workers' history of moves was across school district lines, but the other one wasn't, they would still meet the criteria for recent history, as long as it was a change from one residence to another and due to economic necessity.
Okay. The next one just says when we do the scenarios, that maybe we could clarify what comments are needed.
Oh, okay.
And then another one question was asking about in order to obtain. But that is, that is one thing that, that's no longer in ESSA.
Yeah, so
in order to obtain qualifying work, that's gone.
Yeah, exactly. That criteria for considering someone a migratory agricultural worker or a migratory fisher, asking what the purpose of their move was, what type of work they were looking for, would they have accepted any type of work,
right.
If they couldn't. All of those questions are no longer applicable because that phrase has been removed from the statute. So we did define that term in our regulations in order to obtain, but again, that phrase is no longer applicable, so that regulation definition does not apply under ESSA.
Okay, maybe one more question regarding to join moves. Is there a specific time frame that the child or the worker must join together?
I'm just going to pull up the guidance, but I want to confirm that we did not change that. That was in our prior guidance in Chapter 2. And you want to move to the next one? I'll come back to that.
I'm looking at the next one. One of them was, will we add our comments to the webinar before we post it on results? We'll try to do that. Another question was, is dairy work now a qualifying activity? Dairy work has been a qualifying activity. It was just never spelled out in the statute as it is now. And please remind us where we could download this PowerPoint. This PowerPoint, as Sarah explained at the beginning, will be available on results. And that is results.ed.gov, and we will also announce it on the MEP state listserv and send it out on the listserv too.
Yeah. Okay. So I just wanted to come back to that question about the time that separates the workers move and the child's move for those to join moves. I just want to confirm it is consistent with our prior guidance. We believe that as a best and safe practice, the child's move should generally occur within 12 months of the worker's move. Because after 1 year, it's difficult to link the child's move to the worker's move. And that's in Chapter 2, it's number E4, if you'd like to look at the full response.
Okay. I think it is better for us to move on to the scenarios now because we do have a couple of more questions, but those questions are answered within our scenarios. So I think it would be better to do that. And then at the end, we can see how we offer time in terms of additional questions. So why don't we move on, and we'll move on to the first scenario. Oh, okay. So as we did at the annual directors meeting, we'll present 4 eligibility scenarios that we've developed. And we'll present the scenarios one at a time. We'll pause for a few minutes for you to consider the response, and then we'll share the answer. And just as a reminder, we're going to be looking at these scenarios in terms of ESSA, not in Cell B, but ESSA, okay? So let's go ahead and get started with the first scenario, okay? And Sarah, may I read the scenario?
Yes, it's your recording.
Thank you, Sarah. Scenario number 1, on June 1, 2017, Jessica moves with her 2 children, ages 6 and 8, from Omaha, Nebraska to Wichita, Kansas, to live with relatives after losing her job in Omaha. Jessica is hoping to find work similar to her last job in housekeeping, but finds that she can earn more money in a job at a poultry processing facility. She only plans to stay for a few months to save money and begins work deboning chicken at the poultry plant on July 15, 2017. Are Jessica's children eligible for the MEP?
Okay. We're just going to pause for maybe a minute for you to consider. And we know these scenarios may be familiar to some of you who attended the annual directors meeting, but we'll give everyone a minute to consider before we explain their response to each one. Chance to consider the scenario, and Pat is going to review. There you go.
Okay, so the question was, are Jessica's children eligible for the MEP? Yes, and we're going to go down, and it is an eligibility checklist, and as Sarah mentioned before, we also are revising IDNR materials, and we'll make sure that a checklist will look to see what we had in the past and make sure that that is available on the IDNR curriculum as we move forward.
Yeah, I'm sorry, I did not mention that earlier.
Oh, sorry.
OME is working with our contractor to revise our existing IDNR manual and curriculum. So we, as Pat said, we'll look for any checklists that can be updated that might be useful for you.
Okay, so but we do have the scenarios explained, and you will have that explanation in the PowerPoint. So yes, the children are the children under age 22 and still entitled to a free public education through grade 12 in the state? Yes. Did the children move in the preceding 36 months on their own with or to join a parent, guardian, or spouse? Yes, because they moved with their mother, parent, guardian. Was the children's move with the parent, guardian, or spouse a qualifying move? That is, was it due to economic necessity from one residence to another and from one school district to another? Yes. Is the parent, guardian, or spouse with whom the children moved a migratory agricultural worker or a migratory fisher? Yes. The children's mother is a migratory agricultural worker because she made a qualifying move in the preceding 36 months, soon after which she engaged in new qualifying work, which was temporary employment in agriculture, deboning chicken, which would be initial processing of poultry. Okay? So now we're going to move over to scenario 2.
Oh, I'm sorry. Before we switch over to scenario 2, we did get some questions about required comments on the COE, so I'll try to point those out in the context of these scenarios. So for this one, because the mother, the migratory agricultural worker, engaged in new qualifying work within 60 days of the qualifying move, we would not require a comment on the COE because that 60-day time frame is what we consider to be soon after the move.
Okay. All right, let's move on to scenario 2 then. So scenario 2 is about Joaquin, who is a 17-year-old out-of-school youth. Had not moved since he was about 10 years old. Because he could not find employment in his hometown of Eureka, California, he moved to Yakima, Washington on July 1st, 2017. Within 1 week of moving to Yakima, he applied for seasonal employment picking apples, but he didn't get the job. Is Joaquin eligible for the MEP? Okay?
And then we will pause for just a moment for you to consider the scenario. We will try to move through these pretty quickly. Thank you. Review the response to scenario 2.
Is Joaquin eligible for the MEP? No. Is the child under age 22 and still entitled to a free public education through grade 12 in the state? Yes, and we are assuming in the scenario that he is still entitled to a free public education in the state. Did the child move in the preceding 36 months on his own or with or to join a parent, guardian, or spouse? Yes, Joaquin moved on his own. Was the child's move on his own a qualifying move, for example, due to economic necessity from one residence to another and from one school district to another? Yes, that's a yes. Did he move as a migratory agricultural worker or a migratory fisher? No, because he did not engage in qualifying work soon after the move. Although he actively sought new qualifying work after the move, he sought agricultural work and picking apples, which would be seasonal. He does not have a recent history of moves for qualifying work. Okay? Okay. All right, let's move on to scenario 3.
Okay. So scenario 3, Paul, age 13, lived with his parents in Portland, Maine. Unable to find work in Portland, Paul's father moved on his own to Presque Isle on September 1st, 2016, and engaged in seasonal employment harvesting potatoes within 1 week of his move. Paul's father returned to Portland on October 20th, 2016. Shortly thereafter, Paul's mother was able to find work in a restaurant in Bangor, Maine. So Paul and his parents moved from Portland to Bangor on November 1st, 2016. The Maine MEP identifies Paul on July 1st, 2017. Is Paul eligible for the MEP? And again, we're going to pause for just a moment while you consider this scenario. So hopefully everyone had a chance to consider this scenario. We are going to review the response to this one. So the basic question, is Paul eligible for the MEP? The answer to this is yes. And again, we'll go through the checklist. Is the child under age 22 and still entitled to a free public education through grade 12 in the state? Yes. Did the child move in the preceding 36 months on his own or with or to join a parent, guardian, or spouse? Yes, he moved with both parents. Was the child's move with the parent, guardian, or spouse a qualifying move? In other words, was it due to economic necessity from one residence to another and from one school district to another? Yes. Is the parent, guardian, or spouse with whom the child moved a migratory agricultural worker or a migratory fisher? Yes. The child's father is a migratory agricultural worker because he made a qualifying move in the preceding 36 months, soon after which he engaged in new qualifying work, which was seasonal employment in agriculture, harvesting potatoes. Okay. And I expect we might get some questions on that one, but we are going to go on to the next scenario. Scenario 4. Diana, age 15, and her parents lived in Yukon, Alaska. Diana and her parents moved to Dillingham, Alaska on June 20th, 2016. For as long as Diana can remember, the family has moved to Dillingham each summer, where her father worked a temporary job canning salmon. When they moved in June 2016, Diana's father, Joe, went to the cannery where he had worked for the previous 2 summers and found that the cannery had closed. Is Diana eligible for the MEP? Again, we'll pause for just a minute for you to consider this scenario. 4, the basic question was, is Diana eligible for the MEP? And the answer to that is yes. Again, going through the checklist, is the child under age 22 and still entitled to a free public education through grade 12 in the state? Yes. Did the child move in the preceding 36 months on her own or with or to join a parent, guardian, or spouse? Yes, she moved with her parents. Was the child's move with the parent, guardian, or spouse a qualifying move? In other words, due to economic necessity from one residence to another and from one school district to another? Yes. And we should clarify those are 2 different school districts in Alaska. It's not one of those school districts of more than 15,000 square miles. And finally, is the parent, guardian, or spouse with whom the child moved a migratory agricultural worker or a migratory fisher? Yes. The child's father is a migratory fisher because he made a qualifying move in the preceding 36 months, after which he actively sought new employment in qualifying work, which was temporary employment in fishing, canning salmon, which would be initial processing, and he has a recent history of moves for qualifying work. That employment, temporary employment in fishing, again, was canning salmon, which would be initial processing.
Okay. And then also, this would be one, Sarah, that would necessitate a comment on the COE, correct?
You would need a comment. Oh, no, I'm sorry. Yes, you would need a comment because he did not engage in new qualifying work soon after the move. So when you're looking at that alternate criteria, the actively sought and the recent history, you need to make comments on those. Under the proposed COE, to describe how the worker, in this case the father, actively sought qualifying work, and also to describe his recent history of moves, noting the dates to make sure that they were recent, which, as we said before, we consider to be within the last 36 months, and also showing that there were at least 2 moves because of the plural wording moves.
So just to be just to clarify, there would have to be a comment that is about around the actively sought and a comment around the recent history.
Correct. Yes.
Okay.
Yes. Okay.
All right. Should we pause for questions?
Yes. And we have received a lot more questions, so we're going to try to get through as many of these questions as we can. And as I said before, if your question was not answered during the webinar, I do encourage you to follow up with your program officer in OME if you're a state director. And if you're not a state director, please do follow your normal state process for these types of questions, whether it's going through your region or your state director. And we mentioned if it's a particularly difficult or nuanced question, it might be elevated to OME, but we encourage you to go through your state process first.
Okay.
Okay. With that.
Okay, sure. I'm starting. It says, regarding workers who did not engage in new qualifying work soon after a qualifying move, but sought it and have a recent, actively sought it and have a recent history of move qualifying work, does this also apply to workers who sought temporary employment?
Yes. So again, we're using the abbreviated term qualifying work to mean seasonal or temporary employment in agriculture or fishing.
Okay.
And I think we mentioned earlier, but the definitions of temporary, seasonal, and personal subsistence are still found in the MEP regulations. Those are still applicable if you need more details on what seasonal or temporary is.
Okay. And the next one concerns dairy work. If the family moves housing and changes dairy farms, but they never move out of a school district, are they eligible for migrant services to children?
So this one would be, it doesn't sound like, based on the information here, it doesn't sound like they made a qualifying move. either the parents or the child, or just the family. So in that case, it doesn't sound like the child would meet the eligibility requirements because the child does have to make a qualifying move, which again is across from one school district to another, one residence to another, economic necessity. So it doesn't look like they met that criteria. The other thing, this might be, it's not specific, but this might be referencing the recent history. So if this is about recent history, then I think we mentioned before that recent history, it's just recent history of moves. So it's not recent history of qualifying moves. So moves, that means they just have the two criteria, a change in residence and economic necessity. So that might qualify if that question is just about the worker's recent history.
Okay, all right. Okay, this one is a question about, again, the workers who do not engage in qualifying work soon after a move. The guidance states a recent history of moves. Could we describe again what we consider recent?
Sure, yes. So this is in the revised guidance as well, a bit of a longer explanation, but we consider recent to be within 36 months of the date of the recruiter's interview. So when where a recruiter is interviewing the family, they would ask, have you moved within the last 3 years?
Okay. Okay, and I just brought the slide up okay, so that people can see that. All right. Okay.
I think this is a similar question to what was asked before, but just to reiterate, so the question is, if a family moves housing and agricultural jobs but never changes a school district, and this is not in one of the extra large school districts, I think they mean the 15,000 square miles, are the children eligible for migrant services? And that's a similar answer to the question about, it's basically goes back to qualifying move. So if they did not make a qualifying move, and again, one of those criteria is for one school district to another, which is also consistent with NCLB.
Right.
If they did not cross school districts, and it's not one of the large school districts, and it's not a single school district state, then it appears that they would not be eligible for the MEP.
Okay. Here's a question asking, what is the difference between the child's qualifying move and the worker's qualifying move?
Oh, okay. It might help to, I know this print is tiny on this, but I'm going to go back to the statute. Sorry, it's one of the early slides. Well, there we go. Okay, so I'm just pulling up the statute site. So I would always start with migratory child, because that's who you're qualifying, that's who this program is about. So in migratory child definition, it says that the migratory child means a child or youth who made a qualifying move in the preceding 36 months, either as a migratory agricultural worker or fisher, or with or to join a parent or spouse who is a migratory agricultural worker or migratory fisher. So in the migratory child definition, we have they made a qualifying move. And then when you look at the definitions of migratory agricultural worker and migratory fisher, you see that in defining those terms, those individuals also made a qualifying move in the preceding 36 months and so on. So qualifying move does apply to each one. I'm not sure if that answers the question, but what was it, the difference between the child's qualifying move and the qualifying worker's move?
And I think that maybe this might relate to scenario number 3.
Yeah, possibly, yeah. So in that scenario, if we go back to scenario 3, so basically, again, starting with the child did make a qualifying move, one residence to another, economic necessity, one school district to another. Child made a qualifying move, and he made that move with a parent, guardian, or spouse. And then you have to ask whether that parent is a migratory agricultural worker. And then you look at that definition and say, does the father meet that definition? So the father does, because he's an individual who, within the previous 36 months, made a qualifying move himself, and soon after doing so, engaged in new qualifying work. So this is one of the scenarios, possible scenarios, but there's also, of course, scenarios where the child's qualifying move and the worker's qualifying move are the same. So the child could be moving with the worker, and soon after that move that they made together, the worker engages in new qualifying work soon after the move.
Mm-hmm. And I think this, with scenario 3, goes back to that, the slide when we discussed qualifying move, that in the past, people that have been in the program for a long time, including myself, are used to using the term qualifying move to mean, the QAD, the qualifying arrival date, which is, as we look at the definition now of qualifying move, it is not, connected to the work at all. It is just, as you said, making that move across school district lines for economic necessity, and also across school district lines, economic necessity, and changing the residence. Whereas scenario 3, Paul's father, the child did not travel with the father when the father did the work. He was the agricultural worker. And I think that's what causes a little bit of the confusion.
Yeah, and again, I would just go back to the definitions and see, you're looking at whether that parent is a migratory agricultural worker or migratory fisher. So in the definition of a migratory child, they have to have moved either as a migratory agricultural worker or fisher, or with or to join a parent, guardian, or spouse who is a migratory agricultural, who meets that definition.
Right.
So then you have to determine, does the parent.
Exactly.
Yeah. So I think this is a change under ESSA because we don't have that in order to obtain language, which directly connected the move that the child made with their parent in order to obtain work. So it is a change, and I think it'll take a little while. We'll consider some different scenarios, but, oh, sorry.
Okay, I was just going on to a different question at the end here. Is intention still a required element to establish temporary work?
I'm sorry,
is intention still a required element to establish temporary work?
I'm just going to pull up the definition of temporary because the definition of temporary work in the regulation still applies. Oh yeah, I can see how intent is there if you're relying on the worker statement to determine that the work was temporary. One example is the worker states that the worker does not intend to remain in that employment indefinitely. So in that case, yeah, they're stating an intent of how long they would like to stay or intend to stay. Then again, there's 3 ways you can determine temporary, and that's the employer statement, the worker statement, or the SCA determination. All of that remains consistent.
Okay, and if we have time for a few more questions, going back to scenario number 1, a comment is not required. Are comments no longer required for all moves involving temporary employment?
No, I don't. I'm sorry, what? Say that question again.
Okay, so let's look at, they said scenario number 1. Oh, is a comment, because it's a temporary employment, is a comment needed for all temporary employment?
Oh, I'm sorry, yes, we should have clarified that, and that's consistent with the current COE, and that's what we've proposed in the ESSA-based COE. So if you do check in, this is section 3, number 5, for those of you that are familiar with the COE. If you check that the qualifying work is temporary employment, you also have to fill out the next question, number 6, and it does require a comment for the worker statement or the employer statement, how you know that it was temporary employment. Okay. That's a good clarification. Let's see.
I'm trying to go down and see if there are any other different types of comments.
Oh, okay, let me see. This one about, did we answer this one about dairy?
No.
Okay, so there's a question that says, now that dairy is mentioned in the statute, does it automatically count as qualifying work without the temporary time limits from NCLB? And to clarify, so whether it's dairy work, whether it's initial processing of trees, whatever it is, it always has to be temporary or seasonal employment. So in the definitions of migratory agricultural worker and migratory fisher, it does say that they engage in new temporary or seasonal employment in agriculture, which may be dairy work or the initial processing of raw agricultural products. So temporary and seasonal is always there when we talk about qualifying work. Sorry, we're just reading through the questions.
And some are longer, so I don't.
Maybe for scenario 3,
what is the QAD?
We flip to that one. So the question is for scenario 3, what is the QAD? So remember again, the qualifying arrival date is the date that the child moved with or to join their parent, guardian, or spouse. So let's see, it looks like Paul moved with his parents on November 1st, 2016. So that would be the qualifying arrival date. Trying to see if we missed any questions. Again, we might not get through all of these. We did have some questions about initial planting of trees, asking for specific activities, and that's something we haven't gone into detail in the guidance. We do clarify that initial processing of trees would qualify or be considered qualifying work because it is initial processing of a raw agricultural product, trees. But we haven't gone into detail other than the description that we provide of what is initial processing. So the basic principle applies if before the raw product is transformed into something more refined. I'm paraphrasing here. So we have some examples, I think, with poultry, with, I think, dairy, but I don't think we have anything specific for trees. But if you'd like some more specifics, or if you have specific activities that you're just not sure if they would be initial processing, then we encourage you to send those to your region, your state, or us as applicable.
Yes, that's what we have. Okay. There was a question here. I don't know if we have time to do this one.
Which one is it? Okay, and then we're getting some very specific scenarios. So I think, again, if you could just send those to us after the webinar or send them to your state if you are a local MEP staff, then we can get those results. But I don't think we have time to go through really specifics, especially because we might need some more details in order to give you, to confidently give you a yes or no on some of these. Okay.
Yes. I mean, those are the only questions I see at this time.
Yeah.
Oh.
Okay.
Here's one.
So, okay.
All right, the last one. Let's just do this last one. If a worker engages soon after and is given written promise that they will be given work, but that work does not start within 60 days.
I'm not sure about this question because it says the worker engaged soon after.
Right.
So it sounds like they did the work. But I'm wondering if they mean the worker made a qualifying move and was given some kind of written confirmation that the work would start, but it hasn't started. So engaged, we're talking about actually performing the work. We pointed out that distinction between obtained work, which would be something like this, where you obtain a verbal or a written confirmation that you have the employment. But because the statute specifies engaged, they have to have done the work. So it doesn't sound like they engaged soon after. But again, this is soon after under our definition of soon after, which is 60 days. States do have the discretion to interpret that phrase differently, a reasonable interpretation of soon after. So I would ask you to consult with your state if you're not a state director to see what their specific guidance is.
Okay, and I think that takes care of the questions that we have.
Yeah, I think so. We do have a hard stop at 1 because someone else is using the room. So thank you all for your participation today. I'm just going to flip to our contact information and remind you that you can contact us after the webinar. The slides and the recording will be available on results. We have the website listed there as well as the guidance is on there already. But yes, thank you again. We know it was a longer webinar. We had some technical issues at the beginning, so we appreciate your participation today and look forward to hearing from you. Thank you.
Thank you.